Good morning, Peter and Jennifer. Today we're going to go over the pros and cons of various business structures in order that you may select one for your business. Please correct me if I'm wrong, but to recap, the two of you have obtained a lease to a motel for the next 5 years and plan to run it for the next 5 to 10 years. You do not plan for anyone else to be involved, but do not rule out the possibility of a child entering the business, and only if necessary will you take on an outsider. You have each contributed equally to the working capital and tend to share in the running and the profits. You plan to serve breakfast and will employ a few staff for cooking, cleaning, and serving, and also invest in a vehicle to transport guests. You have no other personal, financial, or family commitments. There are altogether 4 business structures available, namely sole trader, partnership, company, and joint ventures. The only 2 that would be suitable for you is a partnership or a small proprietary company. The most important difference between the 2 is that the partnership is not a legal entity while a company is. In a partnership, you will actually be operating the business in your personal capacity. Thus, for example, the lease will be in your names and not in the name of the business. As a company, the company can take out a lease or loan or own any assets that you may buy for the business. With regards to the method of formation, a partnership is the easiest to set up, and while it is based on a contract between persons that requires the support of consideration, this can be done in terms of an exchange of promises. There, however, cannot be more than 20 partners. It is advisable, nevertheless, to have the terms of the partnership set out in a written document. There are some default rules in Part 2 of the Partnership Act of Queensland, which you can alter to suit yourself. I also understand you plan to continue to use the existing name of the motel in order to retain regular customers. However, this name is a name that is separate to that of the business. In a partnership, you can trade under your own names, but if you wish to have some other name, you need to apply to the Australian Securities and Investments Commission in a manner similar to that of a company. However, in that case, there also needs to have the words Proprietary Limited after it. In both cases, the name must not be in current use. The formation of company is more involved, as you will also need to register with ASIC to obtain a company number. However, the firm will be able to help you handle the formalities, which can be made simpler and quicker with the use of a shelf company, which is already incorporated. Although share capital is required and will be retained till the company is wound up, there is no minimum sum. And as there will only be 2 of you, you can both be equal shareholders and directors. A constitution is not required, and replaceable rules can be found in the legislation which can be modified. No general meeting needs to be called, and you can just make and note any resolutions. There is, however, a small annual review fee to ASIC, who will need to be notified of any changes to the company, such as issuing of shares, change in directors, or address. In running the business, the partnership is very flexible, but the assets of the company can easily become mixed up with your own. Thus, although there is no requirement, separate business accounts should be kept, and apart from your personal ones, as part of good business practice and also to facilitate reporting requirements to the Australian Tax Office. In both cases, an Australian business number will need to be obtained. A small proprietary company is defined as one with less than 25 million in consolidated revenue a year, or 12.5 million in assets and less than 50 employees. Such a company need not lodge a financial statement. However, it should be available if called upon by ASIC. A lot of useful information can be found in Part 1.5 of the Corporation Act, also known as the Small Business Guide, of which I can give you a copy. In terms of liability, each partner is jointly liable in contract and jointly and severally liable in tort committed by the other partner or employees acting as agents. Anyone you hold out to be a partner can also bind the partnership. This liability is unlimited, which will make it risky for your other assets not invested in the business. Although you can take out motel insurance and workers' compensation is available to your staff, you will personally be liable for anything not covered under the insurance agreement, such as a breach of contract or tort by one of your employees. The business also cannot take legal action or be sued, which you will have to do so in your personal capacity. This is where the advantage of being a company really kicks in. The company can sue or be sued as a legal person, but your liability is limited to the value of your shares. Although the company may become insolvent, it will not give rise to personal bankruptcy unless you have given a personal guarantee for any loan. To enjoy this benefit, any contracts entered into prior to the formation of company, such as the lease, will need to be ratified by noting it down and signing it. With regards to remuneration, individual partners share in the net profits, and all profits in a partnership cannot be retained but must be distributed and taxed as personal income. Also, as a partner, you will not be entitled to claim workers' compensation. On the other hand, in a company, there are more diverse ways in which you can get paid. The company can retain profits which may be subject to a different tax rate. It can distribute dividends which carry tax credits. You can also be remunerated as directors or creditors if you make a loan to the business which can be repaid with interest, or you can be paid as employees. With regards to liability among participants, fiduciary obligations exist. Partners are obliged to act in each other's interests with full disclosure. On the other hand, in a company, directors owe fiduciary duties not to each other, but to act in good faith with care and diligence in the interest of the company. The most crucial of the director's duties I can see here for you is that you must make sure that there is sufficient money in the company accounts to pay for debts when they become due. And if there's any knowledge or suspicion that the company will not be able to do so, you must refrain from incurring any further debts. To do so will expose you to criminal and civil penalties under the Corporation Act and make yourself personally liable for any debt. With regards to new participants, it will be harder to bring in new partners, as essentially the partnership will need to be dissolved and reformed, and titles to assets and liabilities will have to be individually dealt with. In a company, however, new shares can easily be issued in your capacity as directors, or some of the shares of the company can be sold or transferred. As the new shareholder will automatically share in the assets and debts, it is much easier to raise funds or to add persons to share in the running of the business. Finally, in winding up the company, in the event that one or both of you decide to exit the business or become unable to carry on, it will need to be wound up or sold. Just as a partnership is easy to set up, it is easily dissolved without any formalities, but the partnership itself cannot be sold as a whole, and each asset will need to be individually dealt with. Penalties may apply under the terms of the lease or loan if still in effect, and will require negotiation with the lender or landlord, even if another person can be found willing to take them over. If the partnership loses money and goes bankrupt, your personal savings will also be at risk. On the other hand, the company can easily be sold lock, stock and barrel, including the lease and all its assets, insurance and loan agreements. This may make it more valuable than in a sale of individual items. If the enterprise proves to be a failure, the business can declare bankruptcy, or the assets of the company may be sold to pay creditors. Your personal assets will be protected. In winding up the company, any money remaining after the debts have been paid will be divided between the two of you. In summary, while a partnership can be set up with minimum cost or requirements, the one big drawback is that you could risk losing all your other savings and assets, and this could negatively affect your plans to retire, especially if the motel does not prove to be profitable. On the other hand, while setting up a company involves some initial costs and inconvenience, This is something the firm can help you with. Running it merely requires the records of resolutions and accounts, all of which is part of good business practice and which you have the skills to handle. The big plus point here is that it will protect your remaining assets against creditors and legal suits. It will be easier to bring in another person to help run the business. And in the event you wish to exit the business, it would be more valuable to sell as a whole. I've also included a list of legislation that may be relevant to you with regard to the fire safety, sale of food, and transport operations, which we can go over. Please feel free to ask me any questions.